of the world's top social media companies are on trial this week for allegedly fueling the youth mental health crisis. Meta and YouTube are right now accused of deliberately designing their platforms to keep young users addicted, inherently harming their mental health. This marks the first time tech giants are going to stand trial in front of a judge. And it comes as TikTok and Snapchat have both reached settlements outside of court before this trial begins. For more on this landmark case, I'm joined by Clay Calvert, media law expert and non-resident senior fellow at the American Enterprise Institute. Welcome to Your Morning.
Thank you for having me. I appreciate it.
First of all, how do you prove intent to keep users addicted, specifically youth users addicted, and cause harm?
Sure. So that's one of the key questions here. The argument is that these social media platforms are negligently designed. In other words, they were designed to hook minors to keep them watching social media platforms. And by keeping them watching, that has caused a rash or a raft of different harms that minors have suffered. Mental health injuries is what they're claiming. Anxiety, depression, body dysmorphia, all types of injuries because they become, the argument is, addicted to social media platforms.
Well, one of the methods on the other side of defense for the companies is relying on a decades-old law, Section 230 of the Communications Decency Act, Meta, which exempts them of liability of a third-party content. That's 30 years old. How useful of a defense will that be in 2026?
Well, that's really the key question. So as you said, Section 230 of the Communications Decency Act is very important. What it does is it provides immunity from civil liability for social media platforms for what we call third-party content. In other words, content that other people post on social media platforms. And so a question the jury here is going to have to sort out is what caused the harm that the plaintiff, in this case she's known as KGM, what caused her harm? Is it design defects in social media platforms? If the jury says that, then that's going to be a victory for KGM. If, on the other hand, the jury says that it's the content that she watched, then Section 230, as we call it, kicks in, and that will prevent liability from the social media platform side. So they would win in that case.
This case is being compared a lot to the big tobacco case in the 1990s. Cigarette companies accused of covering up harms from their products. Where are the similarities, and then how is this different?
Sure. So essentially, indeed, that's what they're trying to analogize it to. We think about the Juul settlement from vaping, opioid litigation, tobacco. The primary difference here, though, is that social media platforms as services deal with speech. They have First Amendment protection. That's the argument that's going to be made here. So cigarettes are not a First Amendment, in other words, free speech protected product. When you're dealing with social media platforms, you're in the realm of expression. And so one argument is that minors have the right to receive speech, and two, that the social media platforms have a First Amendment right to convey that speech to them. So that's how it's very different, I think, than tobacco litigation. We have constitutional concerns in the United States for freedom of expression here that we don't in those types of tobacco litigation cases.
Well, it is an interesting argument, and interesting when you look at it, with U.S. law compared to what we have here in Canada. The impacts of social media on youth is becoming a global conversation, as I'm sure you're aware. Australia has a ban. France just backed a bill for a ban. Canada is reportedly looking to do a similar ban, but we go one step further. Those are for the age of 16. Ours is for 14. If these companies in the U.S. lose millions of users, how does that affect them in the long run? I'm talking about through the use of bans.
Sure, it'll definitely affect them. And one thing that we would look for then is that they would have to change the nature of the platforms in terms of how they deliver content to minors. And so, in other words, just like any product or service, if the plaintiffs here win and the defendants are held liable, then the defendants, the social media platform companies, are going to have to fundamentally alter the nature of the way they deliver content to minors, because that's really what's going on. We've seen a number of different cases, not just here, but now there are chatbot litigation cases claiming that chatbots have caused minors to commit suicide. So big tech is really under attack in these cases, and their livelihood, their financial being is really under attack too.
Clay Calvert, great to have you bring us up to speed on this case, landmark case. Thanks so much.
Thanks for having me. Thank you.
If you like that video, make sure to subscribe to the Your Morning YouTube feed, where you can find all kinds of new content posted every weekday morning.